In the previous video, we discussed certain clauses of the ICJ statute and of this agreement of referral of the dispute of Katha and Supplica before the ICJ. Now, in this video, let's further discuss the various paragraphs mentioned in the moot court proposition and who can argue what based upon what fact. Let's delve into that. So, this para, Katha and Supplica are two neighboring states. Katha is much more economically, territorially, and resource-wise a bigger nation as compared to Supplica. Now, this is not an innocent fact. This is a fact which the applicant, that is, who is the applicant? The Supplica can use in his favor. What Supplicant say? So here you can say in this comment section whatever I am trying to state. So Supplica can argue that even if it was forming an alliance with other countries, still the disparity was so much that it was never a threat to Katha. So therefore any launch of attack by Katha upon Supplica because Supplica was making some agreements with other countries, so that is totally unjustified, because first of all you can't just attack other country because that country is making alliances with another one. But if they say that okay, you were forming alliances with my enemy nation, still the applicant can say that there was so much disparity with our nations that I was never a threat to you. What the counter argument can be made is that in modern warfare the size does not matter, the technology matters, right? And the respondent can easily say that okay, you were not strong enough for me, but we don't know about the treaties that you were having with other countries. Perhaps they were more superior than me, and if not superior territorial wise, but at least technology wise they might have been superior and a threat to me. I'll just give you an example of the recent fight that Armenia and Azerbaijan had. So obviously one of those countries was smaller but still won the war because of a better technology, that is access to more and better drones. So you can have just given the link of this article, which you can read and try to understand from that, and then give this example also if any such question arises. The next line is Supplica also has a history of occasional earthquakes and coastal storms. So even this is not an innocent line. This obviously can be used by the respondent, that is Katha, that since Supplica had a history of occasional earthquake and coastal storms, therefore it was not competent enough to handle the unstable nuclear plant that it had, which was obviously kept at near the border of Katha and Supplica. So therefore not just they were economically poorer or didn't have enough resources, but more above that they also had occasional earthquake and coastal storms. So therefore it was essential on the part of Katha to go into their territory and actually secure that nuclear power plant, because they never knew when it would be blasted and killed millions of people. The next is Supplica has a fully functional nuclear power plant named GPP. So this phrase fully functional, so this phrase can be used by applicant in its favor, and they can basically say that since the fact itself says that the nuclear power plant was fully functional, so therefore no fault can be found on part of Supplica. It was doing very much well. There was no problem with the nuclear reactor, therefore no reason for the Katha to step into its territory vis-a-vis any issues regarding the power plant, because as the fact says it is fully functional. Make use of this phrase fully functional and the judges will deem you intelligent. Next is situated very near to the Katha Supplica border, that is that power plant, and again for obvious reasons Katha can use this line in its favor and say since the plant was kept very near the border, so therefore it was a danger to us. And you can also compare this thing with the famous Supreme Court judgments in the field of absolute negligence, which basically says that if you are keeping a dangerous thing in your territory which is likely to spill over to the other territory, so you can obviously draw inferences from those arguments. Since 1995, it has been a democratic state run by a constitutionally established administrative framework. Now, uh, this is obviously a very positive thing that the applicant can use in its favor and say that it had no mistake and no problems in running its administration or any nuclear power plant, because first it was fully functional, and secondly it says that it was a democratic state run by a constitutionally established administrative framework. I would like to pause at this juncture and make a couple of things clear, that you must appreciate that this moot court proposition is actually drawn on two parallels, and first is India Pakistan, because the relationship shown between the Katha and Seplica is like of India Pakistan, that they were once together and they were obviously didn't receive independence until very late in the 1995 here, but India in 1947, but still there are comparisons made if you read this moot court proposition. The second parallel drawn is between Russia and Ukraine. Obviously, Ukraine was trying to enter the European Union, and that was a major bolt for the Russia, and therefore, amongst many other reasons, this was also a reason for Russian invasion. Russia is obviously here, Kartha, and Ukraine is obviously here, Seplica. So try to read the conflict of Russia and Ukraine, because I think even the judges may ask you upon that and draw parallels from that and give examples from that. So try to read at least a little bit on the basics of Russian-Ukraine war. Okay, now coming back to the discussion. In Seplica, ethnic Carthians constitute largest minority, that is 25%. That is a very neutral fact. What is in favor of respondent? This paragraph. Since Seplica's independence in 1995, several events of discrimination and so forth. So whatever this paragraph is, it is a very dangerous paragraph in favor of the respondent, and they can use it and in fact make an argument of a failed state, that in fact Seplica was a failed state because so and so problems were there. Therefore, whenever there is a failed state, the neighboring state has a responsibility to step in and take measures so that their fault and their failures do not spill over into their country, and therefore it is a preventive measure that has the backing of law. The next is this statement that was made by the president of Seplica, right? And obviously everybody knows that this statement can be used by the applicant in its favor, and I just given certain things in this comment section also. And what can be stated is regarding law and order, that this law and order is an internal matter, right? So I mean, this is basically what the applicant say in its favor, that it was merely a law and order and internal matter. And in fact, you can draw parallel and give example of the racist attacks in Canada and USA, right? Because I mean, there were racist attacks in Canada and USA, but still you don't say that Canada is a failed state or USA is a failed state. So try to give parallels and give examples from real lives, and judges will appreciate that. Next is on 15 November so and so, a national meeting was called by one of the radical groups in Seplica with the name Seplica Reborn. Obviously, the face of it is appearing, and it is in fact a favor in. It is an argument in favor of the respondent, and you can use this line in your favor. But what is the counter of that? That this was without the authorization of government officials. So if the respondent is using this line in their favor, so the applicant can return say that okay, read the full line, that this was happening without the authorization of local government officials, and therefore this cannot be used against us. Similarly, there is conference announcement is there, which you can read and then use in your favor as a respondent. But to the counter of that, obviously when you read the complete paragraph, you can see that this line can be used in favor of the applicant. Similarly, this can be used in favor of the respondent, and this can be used in favor of the applicant. Obviously, I am not going to read out each and every single line, and I am going to attach this Word file in my YouTube videos, and I am going to provide the links to that in wherever this video is uploaded, and you can read actually detailing line by line. And if you have obviously any questions, you can come back to me. Now, obviously, this para is in favor of the applicant, and but whenever the applicant is using, what the counter argument could be that this is a right-wing political party. So what? So there are many political parties in every nation. Some are left-wing, some are right-wing, some are centrally aligned, but no, nothing is wrong. It's just a question of ideology. Some people are say maybe left-wingers, some may be right-wingers, and no negative connotation can be attached to either left-wing or a right-wing, right? So you must not be apologetic about being a right-winger whenever you are arguing. Secondly, when they say that okay, you were making derogatory references to the neighboring country, you can always present a counter that these derogatory references were not against the general population of the country, but we were actually talking about the radicals which are in large quantity in Seplica. The one example is that the Delhi is called a rape capital, right? Everybody knows, but that does not mean that one is calling every citizen of Delhi a rapist, right? It just means that there are a lot of so many nefarious elements in Delhi, and that is what we're trying to say. Similarly, whenever these derogatory references are made, these are made only to specific type of people and not the entire population of the Seplica or Kardha, right? You can also say that there is a concept of puffing up. Puffing up basically means jumla, right? Jumla bazi or bhashangiri, which netas do in political rallies, and puffing up is in fact actually a very relevant phrase in law that is used actually in contractual law. And even with what it basically means is that you do not literally mean what you are saying, right? It is just puffing up, a marketing tactic that you are applying, which obviously is allowed in politics, that you are willing and able to market yourselves, and everybody allows that, right? Nobody takes it literally. And the puffing up is already acceptable in contract law, in legal jurisprudence, because everybody understands that these are only marketing tactics. So I'll just stop this video there, and we'll continue with this legal series, and in the next video I'll discuss furthermore about this legal proposition. Till then, see you.